Good evening, Captain Retired Matt Edwards here with the next installment of the weekly Observation Post report. Now, I'm going to try to keep it to less than a half hour today because last week and the week before I found that my throat was really sore for hours and hours after I was finished this. I'm not really over that infection, the sinus infection. Almost, but not quite. So I thought I'd go back to the usual. I'll do 3 items that I have in my numbered draft list, and then I'll wing it a bit about what's been bugging me recently, where I was talking to a Treasury Board lady the other day, and I don't really blame her because they drank the Kool-Aid, but people shouldn't just believe what they've been told, you know, and that might sound funny for me, but I always back it up with proof. Okay, so number 460 in my numbered list, I say contact the Veterans Affairs Canada Union. Not sure if they'd help veterans. The reason I say that is because they're the ones that enforce the clawbacks. So I was wondering, you know, do they realize that they're harming disabled veterans who were, you know, serving Canada, putting Canada's interests ahead of theirs, and, you know, maybe the union should get behind not harming veterans. I know that's asking a lot. 461. Wage loss replacement rules versus the rule of law. Federal long-term disability does not obey statutory law. Now, I've been saying this forever. Parliament got voted in, people, members of Parliament, and then they made laws to protect things like the Canadian Forces Superannuation Act pension, which is comprised of contributions by the Canadian Forces member during their career, and they put a law in place that prevented anybody from getting their dirty hands on our property. So they put Canadian Forces Superannuation Act Section 83 into law. Then in 1982, they amended it to allow one exception, and that exception is divorce. So other than the case of a divorce, nobody can touch the Canadian Forces Superannuation Act pension. But the Service Income Support Insurance Plan, they take it into account. The Sun Life Policy, 12,500G, they ignore Public Service Superannuation Act, Section 10, brackets 10, and they take it into account. Now, I'll get into that a bit more when I talk about what I spoke to with the lady that's the manager for the disability insurance for Treasury Board Secretariat. Number 462. Canada Pension Plan logic. A. The Canada Pension Plan Act is public law. B. The minimum qualification period is public law since 1998, requiring 4 out of 6 years to qualify for Canada Pension Plan disability. As I read it, I realize it was actually a law before 1998, but the terms were different. It was 2 out of 3 years was the minimum qualification period prior to 1998, but they changed the minimum qualification period for after 1998, which, when you think of it, that takes away their credibility. Because if they had set that rule 2 out of 3 in 1966, they ought to have left it alone. C. Public law is presumed to be known by all. D. Long-term disability administrators are presumed to know the public law. Now, I'm beating a dead horse here, but I'm trying to make sure that no one can be mistaken. E. Therefore, they knowingly force disabled people to apply for Canada Pension Plan disability when they know they cannot be legally approved, at sometimes, proving that there isn't something extremely suspicious happening, so they should get investigated for fraud, among other things. Now, I presume that the civil definition of elements of fraud are similar to the criminal elements of fraud. And besides the civil cases that I've been looking into over the years, I've also had time and opportunity to Google and look up stuff about criminal law. And criminal fraud has 2 elements. The first one is deceit or deception. So somebody has to try to fool you And the second element is that it has to put your economic interest at risk. Now, this is an attempt crime. You don't have to actually succeed. But if you use deceit or deception to try to steal something from someone, you're guilty of fraud. Now, they should not be forcing disabled Canada Pension Plan contributors to apply for Canada Pension Plan so they can benefit from what should be our pension. But somehow over the years, they have gotten it in their head that they're allowed to do this. And they do it to save money, which I'm going to get into now. Okay, so that's the 3 points I was going to talk about. Now, the other day, I called this lady I spoke to years ago, and she's still with Treasury Board, and she's still involved with the disability insurance plan, which is the Sun Life policy. And we had a 45-minute chat. She had a meeting and she had to go, but other than that, I mean, she considered herself an expert, but she admitted that it sounded like I was more expert at this stuff than her. Which is what I told her when I told her that I figured I was the foremost expert in Canada on this stuff. So, some of the things that I was discussing, I was saying, well, you know, the government should admit that it's administrative services only, that they shouldn't lie to the public and to the members of these insurance plans. And this is why I said she drank the Kool-Aid. Oh, no, it's not administrative services only. This is not a fee-for-services arrangement. This has actuarial reserves put away. Now, I've harped on that many, many times, not just tonight. And the thing about that, as I said to her, listen, is there any rule that says an administrative service only policy cannot have actuarial reserves? There isn't, right? Because it's not like somebody's trying to set up an insurance plan that conforms to some definition in a law or something. Basically, and what I've decided to do is not harp on administrative services only because it seems to get their backs up. I'm going to call it self-insurance. Same thing, but a different name. So, first of all, the government has a policy on self-insurance put out by Treasury Board Secretariat. So, the government does not buy commercial insurance. Now, that should be the end of any discussion about Sun Life, Manulife, Great West Life, or Industrial Alliance being the insurer for the 4 federal government long-term disability plans, because the government doesn't buy commercial insurance. It has a policy to self-insure. Now, I also said to her, I said, listen, there was 2 cases. You're with the Sun Life side. You're the representative, the manager for the disability insurance, which is the unionized employees, and the non-unionized employees, that's the long-term disability insurance, they call it. So they got 2 different monikers, names on these 2 insurances. Disability insurance for unionized people, long-term disability for the non-unionized people. So I said, listen, because there are 4 federal government plans, two of them have been to court. Now, Great West Life didn't get sued. Manulife never got sued. It was the Crown. It was Her Majesty the Queen at the time. So, when I was talking to you about CPP, or Sun Life and CPP and all them being administrative service only, well, that's evident from the court proceedings. Because if Manulife was the insurer of the CPP policy, then it would have been sued, and Canada would have been sitting back and watching. Now, that's not quite correct, because the CPP policy on paper is a contract between Manulife and the Chief of Defence Staff, and not the Canadian Forces member. Now, that's where I have a problem too, because I've been harping on the fact that there isn't a contract. even though the judge in the Manouche case said that there was a de facto contract between the Chief of Defense Staff and the Canadian Forces member, I would disagree. He used the wrong word, term, phrase. It's actually what I would call an implied contract and not a de facto contract. By implied, it means that there's no express contract. There's no express words in the contract. And that fact ought to kill off clawbacks. Because here's the way a contract works, okay? You sit down with someone you want to form a contract with. One person makes an offer, the other person accepts the offer, and then the third element is money has to change hands, or something of value. So in the CPP policy, you have the person paying the money, that's the Canadian Forces member, and you had to have someone offering them insurance, which is the Chief of Defense Staff, not Manulife. So there is an implied contract between the Chief of Defense Staff and the Canadian Forces member. But there's nothing in writing saying that they negotiated the terms. There's no union in the military. There is a union in the public service, but they don't negotiate the long-term disability policy. That's something that's not negotiated, like the pension. Now, so the thing is that, all of these things are going through my head, and I'm there shooting down the bullshit she's saying. I said, listen, who pays the premiums? I said, the Canadian Forces member and a public servant, other people pay 15% according to what's on paper, and the government pays the rest. Now, I said that is salary. It's being paid in relation to their service. So even if the government was paying money to Manulife, and I told her I'm not sure that actually happens. Oh, yes, she said, you can trust that. I said, I'm sorry. I've dealt with too much government bullshit to take them at their word. So if the government deducts earned remuneration, I'll use that word. Remuneration is the widest possible term for income. So if you get paid something in relation to your service, it can be referred to remuneration. Now, if the government decides to pay a premium to somebody, and they decide to do it in your name, it isn't their money, it's owed to you. So therefore, it's your payment. Now, I bring this up not just for semantics, but because of the fact that if you pay 100% of your premium and then you become disabled, you are entitled under the Income Tax Act to 100% tax-free payments. Okay? So just because the government says it makes a payment, it doesn't actually make a payment. So she said, oh, it's not part of salary, it's part of Vote 20. And I said, I know about Vote 20. I've been researching this stuff for years. That's the appropriation bill that the government passes each year for public service insurance. And I said, all of those insurances are actually lumped together. It's not like they do one appropriation bill for CPP and another one for Sun Life. No, they're all lumped together. In fact, I was curious about it, so I Googled it, and I found something today, and I don't know if I posted it or not. But I think the 2023-2024 Public Service Insurance Appropriations Bill was something like $3-something billion. Now, that's not the government making payments for insurance on our behalf. That's income. That's remuneration. Now, besides that, yesterday I looked up something when I was doing this, and when I searched my own group for Vote 20, I came across something I posted in 2015 or 16, and it was a description of what Vote 20 is. And it says that this is public service insurance, the premiums, commissions, and all that stuff. But this was the key part, paid in relation to service at public service. So there you go. Now, Treasury Board is the one who puts out these vote appropriation bills, the reports. So according to their own words, any premium paid is made in relation to public service. That's the definition, the test for remuneration, you see? So they're not giving you something out of the goodness of their heart. It's not charity. It's not a gift. It's an earned benefit, see? So that's very important. Now, another thing I was talking about later was the purpose of insurance. Pretty sure I did, and if not, I was going to talk about this anyway. You take CPP, Sun Life, possibly even the Canada Pension Plan Disability. People buy insurance for peace of mind. That is the goal. Now, that's a psychological benefit because you don't get money unless the risk happens. So it's based on what's called a contingent event. So you buy insurance and then you get peace of mind to think, well, if the worst happens, I'll get my insurance and I won't lose everything. Now, here's the problem. They are always talking about the fact that you're buying income replacement. Well, no, you're not. You're basically betting, wagering against some unfortunate event happening. And in contract law, wagering bets are not allowed. They're illegal. But in disability is fortuitous. Now, I always used to think fortuitous meant lucky, but it means that it's just unexpected. You can't plan on it. So because the possibility of you becoming disabled or killed if you buy life insurance, stuff in the throat from like the strep throat thing. So because of that, it's not really considered to be wagering. So they allow people to buy insurance. The law allows people to buy insurance. Now, the thing that I keep telling people, because I read a lot about the law, even if I'm not a lawyer, in the Whitten versus Pilot, Supreme Court of Canada 2002 case, they said that Pilot sells insurance as per its brochures to give people in the public peace of mind. That is their goal. But if you look at all the stuff like the Insurance Combatant, Veterans Affairs, committees, reports and stuff the government puts out, they talk about the fact that CPP provides income replacement. No, that's after the risk happens. The only benefit a person gets before the risk happens is the psychological one of peace of mind. See? So basically they're selling us down the garden path. They're just lying to us. But, they probably don't know they're lying. They just don't realize it, maybe. But here it is. Here, I got it up in my pictures I put in my group today. Insurance contracts, as Pilot's self-description shows, are sold by the insurance industry and purchased by members of the public for peace of mind. Now, the government is not an insurance company. They are not allowed to sell insurance. And that is why they put somebody as a figurehead, like Manulife for the CPP policy and Sun Life for the Treasury Board policy, and they pretend that there is an insurance company selling these policies. But if they were selling the policy, who bought it? The government didn't buy it. The person in the public service or the Canadian Forces member or the RCMP member, they bought it. So there's no contract between these people and these companies. The only contract, if there is one, is between the Crown and these people to administer the policy. In fact, Manulife Here's another picture I posted today, because I've been posting a lot of these pictures to back up my claims. So, there's paragraph 33 of the Manoj case report, the court report. I'll read it all off to make sure I don't miss the part I'm talking about. Indeed, in the context of the extant contractual relationship between the Chief of Defense Staff and Manulife, where the entire risk is underwritten by the Chief of Defense Staff and managed by Manulife, the de facto insurer is the Chief of Defense Staff, and the de facto insureds are the Canadian Forces members. This is consistent with the CPP policy, which was drafted by the Chief of Defense Staff and imposed by the Chief of Defense Staff on Canadian Forces members. Now, you don't impose a contract on someone. Well, they did, but you're not supposed to because of freedom of contract, a common law principle. Canadian Forces members have always paid or contributed to the cost of the program, and the CPP policy expressly recognized their status as insureds. For example, see CPP Policy Part 1, Article 27, CPP Policy Part 3A, Articles 52 and 53. In particular, Article 52, I would have said section, I don't know why I was using article, describes how an eligible member becomes insured under the long-term disability plan. This express recognition of Canadian Forces members as insureds under the CPP policy with their premium contributions are inconsistent with the defendant's argument that the only insured party is the Chief of Defense Staff. Well, it's common sense. It's stupid for someone to say the only insured party is the Chief of Defense Staff. Chief of Defense Staff don't get the insurance. He would if he became disabled, but the members of the Canadian Forces are serving under the Chief of Defense Staff command. So they are the ones who are covered for peace of mind. Now, here's another thing that has me going, sets the devil to me. Now, it's related to, and I couldn't find the paragraph where I could find it later, but the Department of Justice, in their affidavits to the court, said this bullshit. Now, get your head around this. They said that the Canadian Forces members are greedy fuckers. Now, I'm paraphrasing. And they have competing interests with the Canadian Forces members that are not disabled paying premiums and the taxpayer who want to minimize payments, and the disabled fucker who's greedy bastard who wants to get the highest long-term disability insurance that they can. That's where the competing interests are. Now, this is why I think the judge said, in this context, it is the insured Canadian Forces members and Canada, through the Chief of Defense Staff, that have competing interests. Now, Judge, go the fuck back to law school. Insurance is sold to the public for peace of mind. The person who sells the insurance to the public for peace of mind pools, collects the premiums, and puts them into a big pot of money. There is no competing interest. All of the people that are in the pot, the people that are become disabled, get the money later, but they put the money in when they were healthy. There is no competition. Like I was saying in my post today, it's almost like socialism or communism because everybody's doing this for the good of the group. So he shouldn't have mentioned, the Department of Justice shouldn't have brought up competition, competing interest, and the judge shouldn't have mentioned it either. Because think about the stupidity, the monumental stupidity of saying a serving Canadian Forces member who's paying premiums into the CPP policy, and they're under the command of the Chief of Defense Staff who might send them into combat, and then they might become disabled. If they become disabled, then they have competing interests with the person who fucking put them there. Talk about something that will betray our trust, that would cause dissent in the ranks. Now, I might write a column or do a video on this later, but I think it was Sir William Borden, maybe, back in World War I, and before the troops from Canada were going to go into the battle at the Somme, I believe. Not a big fan of World War I, so I might not be right, but I think I might be. He was over there visiting, and he said, "Don't worry, boys. Anything happens to you, Canada will have your back." Now that's peace of fucking mind, okay? The Pension Act was insurance, which provided peace of mind. See? So you're not supposed to take away from people's peace of mind. If you had a person that's going into a war and they were worried about getting killed more than fighting and winning for their country, you wouldn't get much done because everybody would be hiding. They wouldn't want to get hurt. So the government at the time did the right thing and said, "Don't worry, we'll take care of you." That's the only way it could work, okay? You can't have people going to fight in a war and then have them worry about what's going to happen if the worst happens. I hope you agree, because what I say is common sense. Now here's something I'm going to get off topic a bit. Not really too far off topic, because it's about the Manoj case. But I was looking for and I couldn't find yesterday. And I was, sometimes you doubt yourself. Or, I'm pretty sure I saw something about the Manoj case and something being paid about in lieu of punitive damages. Then I couldn't find it. So that made me wonder if I was imagining things. But today I was looking up something else, and there was the picture I was looking for. So let me read it off, and then I'll explain my analysis of it. Scholarship fund in lieu of extra contractual compensation and aggravated and punitive damages. Paragraph 117. Many class members, including Mr. Manoj, advise of the financial hardship suffered while receiving no LTD benefits or smaller LTD benefits than those to which they were entitled. This was particularly so given that many class members described this as the most vulnerable time in their life, having been unilaterally discharged from the Canadian Forces due to a disability. Now that's discrimination usually. You can't fire someone for becoming disabled. To address this issue, class counsel demanded that the defendant provide additional compensation. Paragraph 118. Throughout the negotiations, the defendant took the position that neither extra contractual nor aggravated or punitive damage would be paid by the defendant. This represented one of the most contentious issues between the parties during negotiations. Paragraph 119. After considerable negotiation, the defendant agreed to pay $10 million to establish a scholarship fund benefiting class members and their families. Class counsel viewed this compromise as a reasonable one, given that many class members have stated to me that the impact of the asset had on their immediate family, both emotionally and financially. Now, let me tell you why this is utter bullshit. Complete fucking bullshit. Punitive damages are paid when someone has acted so badly, the word is egregious behavior, that in the common law they're considered quasi-criminal. They are not fucking negotiated with the person who fucking did it. Now I'm getting myself a bit worked up, but I hope you understand. They are ordered by a judge because the fuckers that did it are getting a slap on the wrist not to do it again. And the precedent serves that everybody's not supposed to do it again. See? So this, we had strong negotiations and we agreed to this. Now here's my take on it. They have agreed that they acted so badly that they deserve to have punitive damages. They don't even fucking realize that they agreed that they are liable. Now, they say that, we're going to take the $10 million, put it into a scholarship fund, and it'll benefit for people in the future. That's wonderful. It sounds great. Except it's not fucking fair. Okay, I'll give you a couple examples. There was Witten versus Pollitt, $300,000 house. The company, Pollitt, didn't do enough, and they screwed him over, and they forced him into bankruptcy, and they got $1 million in punitive damages, okay? The damages to compensate them for the loss of their house through a fire was $300,000, so they got $1.3 million. Now, punitive damages are paid as a quantum. You multiply the amount of regular damages, and it could be 3 times, 4 times, whatever the judge decides based on the case, okay? Now, let me give you another example, like long-term disability and taxes. Bruce Brine was a Ports Canada policeman with the federal government Public Service Management Insurance Plan. He became disabled, ended up on that insurance. Then they sent him tax forms, T4A forms, that he didn't think that he should have to pay taxes on. So he took it to CRA. They said, no, you're wrong. But then he went to Tax Court of Canada, and the Tax Court of Canada agreed with him. So they were ordered, CRA, to delete the tax information slip, which meant there was nothing that they could tax because the form was gone. Now, 3 years after that, the insurance company, which was Canada, don't forget, not really National Insurance, National Life, they sent him another T4A 3 years after he had won the tax court case, which was stupid because he had his own case as a person. It's not like me using somebody else's case. It was the same fucking case, the same person. So he went to CRA and appealed, and obviously you think they'd just agree with him because he went to court and won before. Nope, they told him no again. Fucking stuck-up bastards. They think their shit don't stink or something. So he went to tax court again, and obviously tax court agreed with him again. Now this pissed him off, putting all this stuff through, causing aggravation, violating his peace of mind. So he sued them and got $500,000 in punitive damages for breaching his peace of mind on a federal long-term disability contract based on the taxes. Now the taxes was $8,000. So that's a bit high, isn't it? Like 60 times the amount of money that he owed him in 1 year's worth of taxes. So National Life appealed to the Nova Scotia Court of Appeal, and they didn't overturn the case. He still won, but they knocked the $500,000 down to $60,000, which is 7.5 times the amount of compensatory damages. So do you see what kind of a hole the government is putting itself in? Now, 8 times $2 billion is $16 billion. So the government paid $10 million instead of $16 billion. I think we have a difference of opinions about what's fair. Do you follow? I mean, first of all, the idea that you can negotiate punitive damages, that's insane. They are awarded by someone impartial. The government has so much bargaining power over the class members in this case. I mean, it's totally unfair. The fact that they think that this is a good deal is insane. Now, Dennis told me himself, because I spoke to him years ago, and I never saw this, I guess, and I asked him, hey, Dennis, how come you didn't try to get punitive damages? And he said he didn't want the taxpayer to pay too much money. Now, that might be a really recognizable, wonderful goal, but people who treat other people really badly should get a slap on the wrist to make them accountable and to lessen the risk of this happening again. Right? That's the whole purpose of punitive damages. So my mind's not gone. I did find it, and I wish I hadn't, because I think this is going to cause people to get upset with me because I'm criticizing McInnes Cooper again. You don't want to get criticized. Don't do anything wrong. Okay? For example, I noticed in the affidavits that they set a cost of living allowance fix, and it was only from 1999 going forward, and they didn't fix it going backward. Now, to me, that's insane, because the people who got hurt the worst was the people that were getting harmed the most, and that was prior to 1999. So I can guess, make an educated guess, an expert opinion about why they did that, because I believe the government, for these insurance policies, treats each part, each division, as a separate policy. So when they found a problem with the definition of disability that they used between 1969 and 1999, they put a new division in the policy that was different from the previous one, and then they figured that's these people, this applies to these people, and that applies to those people. Now, the legal problem with this, and again, not a lawyer, but I read a lot of law. The problem with this is that in contract law interpretation, before a judge makes their decision, you have to read the contract as a whole. You just don't read a division, an article, or something else, and then you say, though, based on this, here's what we're going to do. No, they didn't set up a new contract outside of policy 901-102. They simply divided it up inside and had different divisions, and they continue to do that to this day, as far as I know. So whenever something comes up, it's like what the government does with grandfathering. Like, I know that the unions in the past, they might have had something that the government wanted to cut back on, and instead of cutting back on everybody, they might say, well, anybody hired from this date onwards won't get as good a pension or something. But anybody that was hired before this date, they will continue with the pension they had in place. So I think that's what they're doing. Okay? Now, let me see if I can find the thing. Now, going back to the tax thing, see, getting a bit dried out, so I think I'll make cut her off soon. But Canada Revenue Agency published in 1979 a thing called Income Tax Bulletin 428, which is about wage loss replacement plans. Now, anybody who was disabled prior to 1971, they didn't get taxed on any insurance payments. So the government was responding to the Carter Royal Commission in 1966 on taxation. And Carter, the fucking idiot that he was, said that every financial transaction in Canada should be taxed. Now, the government didn't accept all, or I don't know how many, of his suggestions, but one of the ones that they did as a result of that was they decided to tax long-term disability insurance, but not all across the board. They said there had to be two conditions. The first condition is that it has to be paid on a periodic basis, like pay. The second one is that if it's been paid on a periodic basis, then the employer must have contributed to the premium. So now, that's the law, but then they put out these income tax bulletins so that people know the government's CRA's legal position if they want to challenge it in court. So paragraph 14, about employer's contributions is the heading, says for benefits received by the employee under a wage loss replacement plan to be taxed in his hands under paragraph 61F, the plan must be one to which the employer has made a contribution out of his own funds. Now, this is where a light bulb went on over my head when I was thinking about that vote 20 and the payment being made in respect to public service. Now, if the government makes the payment, because I'm not sure they actually make the payment to Manulife, Sun Life, Great West Life, and Industrial Alliance, they're not making a payment out of their own funds. They're making a payment in respect to public service, which is what vote 20 said, which means it's pay, which means it's property of the employee. See? Common sense. Now, an employer does not make such a contribution to a plan if he merely deducts an amount from the employee's gross salary or wages and remits the amount to on the employee's behalf to an insurer. That, again, is common sense. So the government deducts what it says is 15% of the premium. But they take something from the employee, money that was earned in service. Now, the question is, and this is something I only thought of this evening, probably thought of it before, but I never wrote it down. To take a deduction from someone's pay, it has to be authorized in law. So it might be authorized in statutory law, like the Service Income Support Insurance Plan, Queen's Regulations and Orders 208.53, which came into effect in 1982. But for the Sun Life policy, it would have to be authorized in contract law, because unlike the military, which don't have a contract, the union, representing the members of the public service, I don't think there's anything there that there's a contract in place allowing you signing your signature on this to say, I agree to let you take this money out of my pay. And I'll give you an example that just popped into my head. A lot of people buy kind of the savings bonds based on their pay. So they wanted to have a chunk of money at the end of the year. They can't save it all the time, so they figures if they gets payroll, the people in HR, to take the money out a little bit at a time at the end of the year, they'll have a bond and they'll go get something for Christmas or something. But they can't just tell them to do it. They have to sign something to authorize that the money get deducted. See? Now, things like the Canada Pension Plan, the Employment Insurance, those are laws. So nothing has to be signed to agree to it. But I would make the argument that the Service Income Support Insurance Plan, because of freedom to contract, that the government writing a law to mandate that you buy insurance violates that common law principle, first of all. So therefore, any deductions being made from your pay is unlawful. Now, one of the things, and again, this is all winging it, popped into my head, 2007 Treasury Board Secretariat Total Compensation Report was comparing the public service to the private sector. And they said the government pays 85% of the premiums and many employers pay 100%. See, there's not much difference between 85 and 100%. In the Watts Tax Court of Canada 1998 case, something about long-term disability insurance, they said that 85% was essentially all. Okay? But what they're missing is the source of the payment. The payment's not coming from the employer as a gift. That's if the employer is making it to a third-party insurer. That's the other part I was putting in when I was writing this up today. Because it says, if you merely deduct it from their pay and remit it to, and they said an insurer, and I insert it like, an editor, third-party insurer. Because if the government, there's no question about it, really, because it was already court. Because the Chief of Defense Staff was ruled to be the de facto insurer, the money they deduct by law is being remitted to the insurer, but it's not a third party, okay? So, if you walked off the street and bought insurance off a company, that wouldn't be a third party insurance. You'd go in, there'd be the first party and second party, and you agree to a deal, and there you go. But if the government bought an insurance contract on our behalf, like they claim they do, then you would have the employee as one party, the employer as the other party, and the third party insurance will be provided by the people the insurance premiums were going. So you'd have three parties, and each party would look after its own interest. Now, on that note, because I was there trying to convince her that the government is the underwriter, the insurer on all these plans, And one of the things that I came across when I was researching things again, and this is my final point, promise, because my throat is getting dried out. When I was reviewing the affidavits, I saw that the government, McInnes Cooper said this in their affidavits, the defendant has always alleged or maintained or whatever that he had had a contractual right to the Pension Act, pension clawback. Well, the problem with that, I'm looking to see if I can find it here in my pictures while I'm doing it. The problem with that is the contract is on the surface between Manulife and the Chief of Defense Staff. So how can the government maintain the position that it had a contractual right to deduct the Pension Act pension when there is no contract between the Canadian Forces member and the government? So, I mean, I find it hard to believe. I mean, I shouldn't say this because people think I'm a kook, but sometimes I wonder if McInnes Cooper was in on some kind of a scam with the government, because there are so many holes in their argument that any competent lawyer would not have allowed this to happen. You know, I mean, sure, it looks like they won, but McInnes Cooper, I mean, I'll throw them a bone, they got screwed over too, because they were supposed to get 30% of the proceeds if Dennis won, 35% if it went to appeal, and they won on appeal. But I'm trying to remember his name. Peter MacKay stood up in the House of Commons. Someone from his own party asked a question about the exorbitant legal fees that was getting paid on the CISIP policy, $13,000 a fucking hour. So Peter MacKay said, you know, we're going to do something about that. So then the federal court, I guess they interfered with the case and charged 8% instead of 30%. So people might say that, you know, that's good for the class, but it has a chilling effect on future litigation because the lawyers think they're getting a big payday. And instead of that, the government interfered with their big payday. So next time someone like Matt Edwards goes to them, no, we won't handle your case, because they know that even if I sign a 30% agreement, that the government won't allow that to happen. They should have left it alone. It would have been better for everybody if they had left it alone. And just for curiosity, because my mind is weird, first one to admit it, I punched in the numbers for if the veteran had paid 30% instead of 8% for Tom over in West Coast, Port Bass area. And by the Jesus, he would have got a tax refund, because the legal fees are tax deductible, see? So you would have had a higher legal fee, but you would have had a legal fee to put against your taxes. Now, Tom actually got charged $15,000 more than he paid in taxes. So they said he had $145,000 in taxable income after he got his damages, but they charged him $160,000, which is $15,000 more than he had in taxable income. Now, I had a reporter lined up to do a report on that, and he said it would have been a national story because a disabled veteran getting treated this way by the government is ridiculous. But he wanted to speak to Tom, not me. It wasn't my case. And Tom developed cancer, and he never ended up talking to the reporter. See? But this is ridiculous, okay? You shouldn't be allowed to mitigate your damages by using the Income Tax Act. Nobody should be allowed to do that, because that's the nature of the money. The class in the Manouche class, they got shafted. They suffered monetary damages, and the money that got paid to them wasn't income replacement, wasn't even insurance, really. It was contractual damages because they should have paid but didn't pay, and therefore in order to settle the legal debt, to get the scales of justice to be balanced, they had to pay the amount of money that they should have had to pay. That's not income, should never have been taxed. First of all, it wasn't paid on a periodic basis. So that's not my opinion, that's the law. The law requires a payment to be periodic or it can't be taxed. For long-term disability, I mean, that's just the rules they put in place. Now, listen, my throat's getting rubbed dry. I'm going to say, hopefully people find this stuff. I mean, I'm getting a bit worked up tonight because I didn't plan to, but this is pretty, to use the word for punitive damages, egregious, okay? This is not how you're supposed to treat people. You're supposed to treat people with respect, especially if they put their life and limb on the line for the country and became disabled in the name of the king, okay? Thanks for watching. I'll see you next week.